International and Graduate Studies here at Seattle University School of Law, and I oversee our Masters of Compliance and Risk Management. My information is there below, but I will share that at the end. I am super excited to introduce our guests on our panel today, and I will let you all introduce yourselves. First, we have got Tracy Kosa, and she is an adjunct professor and has her PhD, and I'm not even going to try and like highlight what it is that your specialty is and what your dissertation was in, but I will let you try, if you would, Tracy.
Sure, happy to. Thanks, Kelly. Good to work with you again. And Frank, I'm glad you could join. So my background is a bit interdisciplinary, which is why it's always fun to try and explain it. I started out in political science and international human rights, and then migrated over into computer science, because what fascinates me is really the intersection of the expectations around law and human rights with technology, and specifically, of course, how privacy can or cannot be enabled in a computational system. So I'm excited to be here to talk to you today about the technical aspects of some of these issues, including some interesting ideas around data brokering and what happens to our information.
Awesome. Thank you so much, Tracy. And I'm excited to work with you again, too. I know we have intersected at Seattle U several times, and I love working with you in this program. So, and Frank DiMarino, who is our principal faculty member in the Masters of Legal Studies in Compliance and Risk Management. And I love working with Frank very regularly. We've become fast friends. And I love chatting all things criminal procedure and federal prosecution. So Frank, if you could take a few minutes and introduce yourself, that would be great.
Indeed, Kelly, and I value our friendship too. And Tracy, it's so great to be able to co-teach another course with you this term. And so we're already in our fourth week. So my background is from the federal prosecution side. I was an assistant United States attorney in the states of Florida and in Georgia, prosecuting mostly economic crime. And so I come from an operational aspect of compliance. I was also involved in supervising compliance programs or monitoring compliance programs with corporations who were facing court orders as part of their sentence to develop a compliance program and make it effective. And so I've been at Seattle now as a professor for 4 years.
Yes, and we love having you. So thank you both for being here. I really appreciate it. And I'm super excited for today's topic. So our agenda today is just a really brief overview of Dobbs and the opinion and kind of what it means for us to be in this post-Roe world. And then Frank is going to give us an overview of the law enforcement implications of the Dobbs opinion. Well, and kind of law enforcement generally, so we have a basis to then transition to Tracy's component around data privacy and some of the compliance issues around data privacy. And then we're just going to chat a little bit about what does this mean for compliance and where rubber meets the road around law. And I mean, I'll do my best to facilitate. This is really where compliance and law intersect, and where I think compliance is definitely an extension of law, but there are implications for compliance that are very separate from legal doctrine. So hopefully we'll get to tease those apart a little bit, and you'll get to see kind of where this program is a part of the law school and why it should be part of the law school and why it's a legal education, very much so, but also why it's super separate. So here we go. I will just kind of provide a very brief overview. I would love to spend, I could spend hours talking about Dobbs. I'm sure that there's many, you could, Google YouTube videos and all those things. Many people have spent hours talking about Dobbs and Jackson versus Jackson Women's Health opinion. So in the June, the court released their opinion in Dobbs, which effectively overturned the federal protection or constitutional protection for or constitutional protections for the right to receive termination services or abortions federally, right? So now it is up to each individual state to determine whether or not a woman or a person with a uterus has the right to terminate a pregnancy and at what point they have that right. So that's effectively what Dobbs says. And without trying to get too far into the nitty gritty, it overturns Roe versus Wade, which was decided in 1972, if I'm not wrong. I don't know. Yeah. Okay. There was also Title IX, which is why my area of expertise is Title IX. So that's how I remember that. So I don't know if you all want to add anything beyond that. Again, trying not to get too far into the weeds. Nothing.
That explains it very well, Kelly.
All right. Sounds good. We'll keep going. And I'm going to turn it over to Frank.
Okay. And I maybe should just have a quick disclaimer. We're going to be talking about some controversial issues. And so my views are not meant to be those of Seattle University or any other organization for that matter. You know, I look at our conversation as just one to kind of explain and explore the issues around the post-Roe world that we now live in. And so some of the law enforcement investigative tools that could come into play when investigators, whether they're federal or state investigators who are beginning to investigate a crime, one of the things that, of course, could be pursued would be a search warrant. And it must meet the Fourth Amendment requirements, one of probable cause, showing that there is property that is related to a crime, okay, that will likely be found at a particular location, and that the application for that search is narrowly confined. They just can't be looking every place. That information has to be presented to a judge, and then the judge will either grant or deny the warrant. And then the warrant has to be carried out according to the court's order. And so when a company, and we'll be talking about this more during our webinar, when a company is faced with a warrant that's been properly signed by a judicial authority, it is very difficult for them not to abide by that warrant and to let the investigators in and to obtain the property that's described in that warrant. As a matter of fact, the only way they can contest it is really after the information has been released in many cases, unless they can apply to the court for an emergency relief situation. So a warrant is a very important tool for law enforcement in this area of gathering evidence. Also a grand jury subpoena. So long as the grand jury is duly constituted and is involved with an investigation of a crime, and so long as the subpoena is not overbroad, the subpoena too has to be complied with. So in other words, the only way then that a party could contest that subpoena is by moving to quash that subpoena before court. And again, the grounds for the subpoena are that, was it overbroad or is it too vague? And if it's not, then it typically passes the requirements for a grand jury subpoena. The All Writs Act becomes in play here also. And just as a history nut, the All Writs Act was actually signed into law by George Washington in 1789. So that's how far this goes back. But why is it important to us today? Well, recently the All Writs Act was applied to require Apple, the maker of our iPhones, to create software to bypass the security that would cause an iPhone to be locked if the user or the operator in the iPhone attempted 10 incorrect passwords. So here's the picture. Law enforcement obtains an iPhone, but they don't have the password to get into the iPhone. And so they start using some passwords and they realize that, hey, listen, if I use more than 10 incorrect passwords, the iPhone's going to be locked and it will cause all the information on the iPhone to be wiped away. So under the All Writs Act, law enforcement can apply to a court and ask Apple to develop software to overcome that security mechanism on the iPhone. Also administrative subpoenas. can be used in this area for child abuse, for neglect. Administrative agencies can issue a subpoena and also obtain information and evidence that would be helpful to a prosecution of a crime. So if we could perhaps talk about our next slide, which is evidentiary information that would be probative for law enforcement. In other words, what is law enforcement looking for? What kind of information are they entitled to get underneath these 4 tools that we've just described? Bank records. So what that means then would be deposits, withdrawals, credit card transactions, the individual transaction on a person's credit card. Those can be obtained. Money orders. All of that information as to who the money order is made out to, how it was spent, that information can also be obtained through those tools that we just talked about. Phone records, okay? So who is being called, where the call is placed from, okay? The duration of the phone call, that kind of information also can be obtained pursuant to these tools. Now, to get the contents or to wiretap, that takes special permission under Title III. And so that's for an area really outside of our conversation today. Historical cell site location information. And so that information can be obtained as to tracing a person's whereabouts or where that mobile device has been used from the different cell sites. And so that could help law enforcement to determine where that person has been, how long they were there, and where they went afterwards, and what their route was, and perhaps what they did after visiting a particular site. Geofence. That information also can be obtained by law enforcement. What that is simply is setting up a perimeter around a particular location. Okay, so let's say, for instance, it's around a clinic, and a geofence can be set up so that any mobile device that enters into that perimeter can then be recorded that that device has breached that perimeter, that geo perimeter that's set up electronically, and that can be recorded by law enforcement. Also, smartphone apps. You know, these are things like a fitness tracker on your Apple Watch, for instance, or on your Fitbit. Also, the apps dealing with menstrual cycles and any other app that has other health information. That information that you're transmitting about yourself through the cellular data, that can be obtained also by law enforcement through those tools. And since that information has been released, for instance, to a third party by using this app, a search warrant doesn't have to be obtained. It could be obtained simply by a grand jury subpoena. So let's talk about some of the pending legislation. In other words, what is on the horizon? And so this is all pending. So these are statutes that are working their way through committees in the United States Congress. Whether or not they will be passed, that's for a topic for another day. But so far, this is what's being debated in the House and in the Senate. One is an act called My Body, My Data Act of 2022. And if enacted, it would create privacy protections for personal, reproductive, or sexual health information. And so the goal of that act would actually try to protect information about women's decisions regarding their reproductive and sexual health. Also, another very large statute that is being considered is what is known as the American Data Privacy Protection Act, or the ADPPA. And so what this does is it gives consumers, okay, the right to access, correct, and delete data about themselves that are held by covered entities. And those entities are described or defined by the statute. Doesn't include all entities, but for most part it does. And also, most importantly, this particular legislation creates a private cause of action for individuals to bring against those entities in case those entities have violated the ADPPA by perhaps releasing their information in an unauthorized fashion. So I think it would be worthwhile to perhaps talk about a couple of cases that have made the news. And one case is Nebraska versus Jessica and Celeste Burgess. And that case involves a subpoena that was issued by a duly constituted judicial authority to Facebook to obtain the Facebook, the messengers, the messages on Facebook about a mother's and a daughter's conversations dealing with a pregnancy. And the investigation was actually triggered by a situation dealing with the improper or mishandling of physical remains. And what came out of this particular statute, of this particular case so far, is that this information obtained from Facebook actually disclosed that the daughter had taken abortion pills and that caused then the death of the fetus. And it's a fairly long story. We can get into the details more in a question answer period. But the key here for this particular case is that Facebook messaging was able to be used in this case to further the law enforcement investigation dealing with the disposal, the unlawful disposal of human remains. Also a second case, and this leads us into what Tracy will be talking more about, and that is the Federal Trade Commission versus Kochava Incorporated. And Kochava is a data brokerage company that obtains data, packages it, and then resells it to people. This particular case involves a complaint for injunctive relief against Kochava to stop them from selling this information as a data broker. And what kind of information is it? Well, maybe if I could just spend a quick second here by actually reading paragraph 25, it's not long, from the actual complaint seeking injunctive relief against Kochava. And it says that the data that Kochava had could be used to identify consumers who have visited an abortion clinic and as a result may have had or contemplated having an abortion. In fact, with the Kochava data, the complaint further alleges, it is possible to identify a mobile device that visited a woman's reproductive health clinic and trace that mobile device to a single family residence. That data set also reveals that the same mobile device is at a particular location at least 3 evenings in the same week, suggesting the mobile device's user's routine. This data may also be used to identify medical professionals who perform or assist in the performance of abortion services. And so, as a further example of the kind of data that Kochava was collecting and then reselling, also involved identifying a mobile device that appeared to have spent the night at a temporary shelter whose mission it is to provide residence for at-risk pregnant young women or new mothers. And so the Federal Trade Commission, in its power to enforce regulations dealing with deceptive and unfair practices against consumers, have sought injunctive relief against Kochava Incorporated, an Idaho company, and prevent them from further selling this type of data. Where this case goes, we don't know yet. These are all allegations, and it's pending now before the District of Idaho. So Tracy, I know that you have some important thoughts on this, so I'm going to turn it over to you, please.
Thanks, Frank. I think that's a great introduction. So I'm going to step back just a little bit. The infographic on the left here, I've shamelessly sold and sourced in the notes. It basically is intended to give you an idea of the industry for data brokers. So worldwide, we're talking about at least 4,000 companies, probably more, because these are ones that are just registered in the United States. To give you an idea of the scale of what they have, Axiom's one of the largest data brokers in the world. They have 23,000 servers dedicated to the collection and analysis of customer data. We estimate they have approximately 500 million customers, individual customers on file. But the really interesting part about that is that the average for these profiles for each consumer or customer is about 3,000 data points per person. And when we're talking about that kind of scale, we are really talking about a very effective way to both track and manipulate human behavior, which is really what data brokering is about. Every time you hear the words advertising, I want you to think of manipulation. It's not just about selling you data, it's about manipulating where and how you choose to share that information to get you down to the level of detail of, say, how you might vote in the next election. So these profiles are not just about selling. Before abortion was illegal in the United States, which I agree with Kelly, I think was 72 or 73, we didn't have personal computers and smartphones that tracked every one of our moves. So all of this data that people are producing is really what's sparking a renewed concern in privacy rights that we see in this legislation that's being proposed. But for years, brokers have sold data sets on expectant parents. That includes their trimester status, their preferred birth methods, their providers, their medications, you name it. 30 different listings from a cursory search I did before this webinar from data brokers offer information on expected parents and are selling access to that information through mass email blasts. Approximately 20 of these were updated after the Supreme Court's ruling, which means that more information was added to those lists as available to sell. On the right, you'll see two examples of such mailing lists. I'll tell you about those in a second. Two other companies that sell these lists, Exact Data, sells a data set that contains information with name, emails, and mailing addresses for up to 23,000 expectant parents for about $2,700. So we're not talking really expensive information to get a hold of. You can also purchase raw data on pregnant women, people with uteruses that include location, age, and income. And you can cross divide all of this, of course, by location if you're interested in specific states with more prohibitive restrictions. Complete Medical Lists is another company. They offer 585,000 mailing addresses for expectant parents and email lists. The data from the 10, I believe, as of today, states where abortions are completely banned makes up half of that data set, if not more. On the right, you'll see the inquiry that I made personally. I just wanted to see, could I get this information? I got an offer for 20,000 mailing addresses, emails, and full demographic information for women who are assumed or thought to be pregnant or planning to be pregnant or seeking abortion services in under 12 hours for the cost of $2,000 divided by state. So this is information that anybody anywhere can get. Kelly, next slide. What I wanted to highlight, and I think Frank did a great job of this already, so I'm just going to hit it very quickly, is this isn't just about your fertility and health information, right? Search engines collect all this personal information, privacy policies, which none of us read and are accepted, means that any authority can request any of that browser history. It can also not just be because of warrants, it can be just because they asked nicely. And of course, as we saw from the previous slide, you can also purchase the data. Online searches can turn into online sales. So of course, receipts for abortion pills, illegally obtained or legally obtained, might very well become the most requested item from online shopping brokers. And then, of course, you have period apps and fertility tracking applications. The Mozilla Foundation did a study recently and determined that out of the 25 apps, the top 25 in the local iStore, the majority of them do not provide clear guidance on what data is shared with law enforcement. Several of those apps didn't even have a privacy policy. So it's definitely worthwhile considering your use of those. Location data, of course, as Frank mentioned, is astonishingly accurate. It can pinpoint location to a few meters, and that, of course, can be inferred to ownership, behavior, and any type of activity. Next slide, Kelly. So where does this get us? There's a real interesting problem here of law enforcement and big tech and advocacy. So Clearview is a company that was in the press for quite a while. They call themselves a revolutionary intelligence platform that includes 20+ billion facial images sourced from the public internet. The reason it was particularly interesting is because over 2,000 law enforcement agencies across the United States use these kinds of forensic tools, but Clearview can be used without your department authorizing it. So you can just download a reasonable full service version of that app and put it on your phone. We, of course, have seen access and transparency requests on the right, sorry for the eye chart, really skyrocket in the last few years. And most companies just give the data over. To Frank's point, they don't have a lot of choice, which makes it fascinating that Google decided in the recent weeks and months to make a decision to encrypt sensitive location data. This makes good press and may very well protect some people. But as we can see from the previous slides, it isn't necessarily going to actually protect the privacy of the people who are most vulnerable. Next slide. So Biden's executive order is what the critical response has been to date, which is all of these interesting things around emergency care and medication abortion and enforcing and pushing for public education efforts and bringing forth more of the light shining on deceptive practices. But what's particularly interesting about this for me is that there is an express call out to protect reproductive healthcare services for federal workers, for service members, for DoD and military families, which would suggest that we're moving towards a place where we're further aggravating who can exercise what rights based on what role they play in our society. Next slide. So what do you do? Well, if you're using a period or fertility app, you should at minimum check out what the privacy policy is and then seriously consider going back to a pen and paper. Online searching is always going to be a problem. There's various ways to protect yourself, including using various VPN services or firewalls. They get really technical really quickly, but unfortunately, we're at the point in society where we're going to have to educate ourselves about the dangers of the way we use information online. Location tracking should be turned off at all costs for any app. And I know that Apple has features that allow you to do this, as does Google, at a scale level for each of the apps on your phones. And of course, it's imperative to be very careful about online forums and online discussion boards that you may or may not be involved in. Having a username does not give you anonymity. And that's the really important takeaway here. I think that's it for me, right, Kelly? Yes, I brought that just in case there were questions.
Oh, geez Louise, man, you'd think after 3 years we'd figure out the mute button. So yeah, so I'll leave this slide up for kind of just general contact information, but certainly, well, and maybe I'll minimize it and put it up later. We can stop sharing. We can see everybody's beautiful faces. Yeah, I wanted to kind of open it up for questions and I can facilitate some discussion here. I am really kind of, there's so much conversation also around the mobility, right? So now that we've got this network where we have some states, right? So the Dobbs opinion really kind of sent the question of termination services and abortion care down to the states. And so we've got some states who, Washington state included, where Seattle U is, where abortion access is still very readily available. We at Seattle U just had a panel discussion on campus earlier this week. One of the issues, of course, is that now those services are impacted because folks are traveling in. We border Idaho, and Idaho has one of the most restrictive laws either in place already or coming in into effect. And so wait times are getting longer, et cetera. But now that folks are traveling across state lines to access care, how are those issues being, how do some of the issues that you all have talked about impacted by some of these travel restrictions or laws? What's your take on those? You're muted, Tracy.
Frank, do you want to jump in, or would you like me to give my data side of the question?
Go ahead, Tracy, and go ahead and start.
Well, I think from my perspective, the idea that you're leaving the state to receive the care makes perfect sense and can create a false sense of security from an information perspective. But the truth is, as we've gone through, there's multiple ways that you will be tracked and traced, and that behavior can be shared even if you don't want it to be. And certainly in some of the more restrictive states, there are well-known mechanisms for punitive, I would say, harms to someone when they return. There was one state in particular, and I'll leave it to the lawyers in the room on this, but where if you drive someone to seek abortion services out of state, you could be punished, you could be charged, and I think things like that are the pieces that people may feel there are outs or workarounds, but the technology that we all rely on every day is betraying that. And so there is no sense of security or privacy in that respect anymore.
Yeah, and Kelly, I think that the point that you raised is the biggest drawback and the biggest issue now since Roe has been overturned. And that is the burden now that is put on women to obtain reproductive care. And so we're requiring now women to go to a different state. When we're one nation, we should have a federal law that protects the women's right so that they do not have to move from state to state to get the reproductive care that they believe that they need, and have a decision between themselves and their own doctor there. And so what we're really doing is creating a burden that hurts the underprivileged even further by this mobility requirement. And also, I think it creates an additional stigma too on women who are seeking an abortion. So, but Tracy hits the nail right on the head. This information can be collected. It's just because you're going from one state to another for this care does not mean that it can be done anonymously. It can be collected, it can be captured, and it could be used.
Right, absolutely. I think so, kind of taking that, right, that's like the legal picture. And we talked earlier about how, there's a very good reason why our compliance programs are within the law school, right? It's absolutely connected to the law. But they're separate in that there's very much a business component and an operations angle to compliance. So who's responsible then for protecting this data? Right. So the data lives in a place, and there's hackers and folks that can potentially access the data impermissibly. And then there's law enforcement and folks that can access the data permissibly. And then there's this like middle ground where you were saying like, well, you can ask nicely and maybe, the data will just be handed over. Right. So what are the ways that folks can access the data, and who's responsible for gatekeeping?
Yes. So again, this is one of the things that we teach in our compliance courses, is that the compliance officer should not be an island. The compliance officer needs to work with the different officers in the corporation or in the organization so that they can create really a program, so that they can create a strategy pursuant to the company's policy of privacy, and make certain that the goal of privacy is being protected. If the compliance officer tries to operate independently or without sufficient resources, they're going to fail. And so they have to have truly a seat at the table with the board of directors to have sufficient resources and a strategy that the corporation works toward, with the IT folks, with the general counsel's office, again, with compliance, with all of senior management, so that everybody understands the boundaries for the use of the data and how that data has got to be protected. And also the consequences if that data is released outside or in violation of company policy.
Yeah, I think to build on what Frank said, it's a team effort, but it's also made in the context of a business decision. And those business decisions can be things you don't agree with. And so in a lot of cases, the privacy policy is intended to cover off these uses and be that statement for an organization of how they will choose to manage data. And that takes you from the legal obligation through to what is the company actually going to do and what are they committed to. It's similar to terms of use for any given service. The problem, of course, is that nobody reads the privacy policies, so they're not necessarily aware of what risks they're taking. And also, most of the requirements around this, and I use the word requirements loosely, like obligations, legal obligations, contractual obligations, you name it, are things that are considered as part of a reasonableness test. So if a company does what is reasonably required from a security and privacy perspective, and the data is still leaked, the data is still hacked, the data is still taken by law enforcement, then they have done their due diligence. I mean, the real problem here is that we have a free-for-all when it comes to the use of data. So activist groups can easily write up privacy policies that say we're going to respect the use of your information. As long as it's legal, they can do whatever they want with it. And so that's where you get into this weaponization of our information, particularly in a political context of the one that we're in, but also especially on an issue like abortion that has become such a hot button in the United States.
Right. No, you're right on. And it segues really well. This is going to be my last question to both of you. And certainly if, the attendees have any questions, you can put them into the Q&A or into the chat. So when I'm teaching any sort of legal issues class, whether it's undergraduate, graduate, law school, I am very cognizant, right? My years in business, my years in law, that there's always kind of like three prongs to an issue. There's like the business answer, right? And sometimes that's a P&L, like profit loss. Sometimes that's, your shareholders, whatever that looks like. There's the legal answer, and then there's the ethical answer. And if you're lucky, never happens. If you're lucky, those three are kind of aligned, right? So, right, it's like dovetails really well with what Tracy was saying. And what Frank was saying, it's really important. We talk about this so much in our classrooms in this program. It is so important for you to have all of these stakeholders in the room and for the business to have a really well-defined vision and framework for making these decisions well before these issues come up, right? Because you need to have some sort of something to lean up against when you're making these decisions, and where's our value system, right? Where is our ethical line? Because without that, it becomes really challenging to make these decisions quickly. So my question to you all, and I frame this because our kind of tagline for the program is compliance with the conscience, right? We really, both at Seattle U, both in the program, but also at Seattle U and Seattle University School of Law more broadly, we really kind of push up against some of these harder questions. Because so often the business and the legal answers don't inform the ethical questions well. And as leaders, as business leaders, not just compliance officers, not just COOs, right? Not as board of directors, the ethical questions are the hard ones. So my question to you in closing is, given those three prongs and this issue, in the context of this issue, which prong is more important? Is there one? How do you make this decision in protecting data?
Yeah, so I'll take a first stab at it, Tracy, if you don't mind. And so this is, I think, one of the more enriching experiences that I have teaching at Seattle U is with the discussions that we have in our classes about what does it mean to be able to do well by doing good. For instance, in our sustainability and risk management course, that's one of the chief things that run through the entire course. And so sometimes it depends, right? We have to consider all of the stakeholders that are doing business with a particular corporation, where that corporation is located, what impact it's having on the community, what impact is it having on the supply chain, and whether or not the companies that are providing supplies for the corporation to manufacture its product whether or not those suppliers are acting unethically, and how far down should we try to exercise due diligence in managing them. And so it becomes a very fluid and variable set of factors that you have to consider as to whether or not a company is acting ethically. And so the best way I think that that we have learned from our discussions is that it has to be a question that is raised all the time. It just cannot be raised, for instance, when a report is being prepared for the board of directors as to how many ethical complaints we may have had or how many times a whistleblower has raised an issue. It is an issue that has to be confronted with almost every business decision. What impact will it have on the larger good? What impact will it have on the public good? And then I think that officers of a corporation can begin to act with a better conscience and be more productive members of society. So those are my thoughts.
That's hard to follow, Frank. I think that after spending 25 years playing around in the issues of privacy and technology, it's really easy to say that the ship has sailed and it's too late. And so why bother even worrying about the ethical aspect of things? But that's kind of the easy answer. The real answer is, of course, much harder, as it always is, which is that it's going to be up to you in the role that you choose to play. So I've seen lots of people decide that compliance is their career, and they go in and they want to make the board happy and they want to make the leadership happy. And then I've seen lots of people say, I want to go in and represent the right thing. I want to go in and push for the right thing to happen. And if I'm the only person who's doing that and I lose every time, that's okay. And having been in those shoes myself, it's a hard place to sit in. You know, nobody loves the compliance person in their company. You have a big road ahead of you, but it also means that every morning when you get up and look in the mirror, you can be really comfortable that you're doing what aligns with who you are. And I think the framework for a lot of these conversations and decisions has to come down to intentionality. So the reason the abortion one is so perfectly framing of this tripod that you described, Kelly, in my mind, is that it's an exceedingly personal decision. And the intentionality around the protections that we created as a society, like HIPAA, really are showing where the gaps are in those conversations. You know, a lot of the information that we discussed today isn't protected by laws that we have today on the books, because those laws speak to context. They talk about disclosures of health information in the provision of care. They don't consider me disclosing my health information to my friend on WhatsApp.
Right.
They don't consider those outliers. And so I'm going to go with ethics, even though it doesn't always win.
No, I really appreciate your candor, both of you. And I'm going to throw up this slide as we kind of wrap up here, but thank you all for joining us, and thank you both for your candor and your time. I so appreciate everything you bring to the table and all of your, I mean, these are the discussions we have every day, right? And I think that candor is a part of compliance, and it's a part of being a good leader. And just kind of like last parting thoughts, you said that sometimes you want to go in and say the right thing to leadership, and you know, the choice is like the right thing to leadership and do what the leadership wants, or being, you know, doing the right thing like for your heart and like ethically. Hopefully those two things will align too, right? And I think we're getting there more and more every day. So thank you both so much. I love working with the two of you. You both like just made my whole day, so thank you. Thanks for your time. Thank you all for joining us. Feel free to reach out if you have any questions. I'll stay on the line for a little bit if everyone, if anybody wants to chat or anything. But Frank and Tracy, feel free to log off if you like and get on with the rest of your day and get back to work or whatever it is you're doing, or recovering from a hurricane. So thank you both.
Thank you.
All right,
Bye.
talk to you soon. Bye-bye.